So now we'll begin with the third module of business contract drafting, which is basically, sorry, not the third module, the second module of business contract drafting, which is explaining the concepts of contract in more details. When you talk about a contract, we in our last session did the basics of contracts, which included the contract act, the modules, etc. So now we have the essentials of contract, okay, technical terms. But these technical terms, they need to be, uh, you know, they need to be embedded in a contract so that you have a contract which is enforceable by law. Contract is nothing but law which is enforceable, sorry, an agreement which is enforceable by law. You have an offer, that is, I am offering something. This offer can be in form of a tender, this offer can be in form of an advertisement. So when you see an advertisement in newspaper, okay, saying that flat available for rent for 3 months XYZ, so that is an invitation to an offer. uh, Similarly, for tenders, you have these tenders saying that government is building XYZ highway and it is inviting tenders from infrastructure companies. So that is your invitation to offer. Now, once all your concept of offer, invitation to offer, lawful consideration, etc., are done, then comes why do we need to have contracts, okay, especially in the business world. So let's talk about corporate contracts now. Legal drafting is very important for business owners because it is not an option. Most people think that just because you most people think that just because you understand the you understand the basics of how a business works, it means you don't need to enter into a contract. But unfortunately, the reality is not like that. Most of the startups fail, or most of businesses, they fail in the first few years because they don't have anything in writing. The first thumb rule for any contract, okay, is to have everything in writing. Nothing is on trust, nothing is oral. Until a few years ago, business was done on relationships, that two partners are there, they know that X company will give me the raw material on so and so date, only it will come. There was no need to enter into an agreement with the transport company saying that on so and so date, please send your trucks to pick up my raw material, send XYZ type of trucks. There was no need to do it because most of it would happen over a phone call and with trust. With the West entering, with the MNC entering, now business is also becoming corporate. When I say business, it's a local business, and therefore drafting a proper agreement which will save you from the crisis is very important. Now, so many times we have heard stories from our friends, our relatives, that so and so relative took money from him, and he didn't turn out, he just ran away with the money. So why did you lend the money without any proper documentation or without any proof? That is why that person took loan or whatever and ran away. Coming down to the present day contract drafting. Okay, so when you're talking about present day contract drafting, one, you need to be very clear on what are the deliverables of both the parties. Sit with both the parties and identify. Now, this is your role as a lawyer, because your client will not know that even this is my deliverable, even this is my deliverable. you may not know the nature of business, but then there are standard A, B, C, D deliverables that you have to ask. Okay. Contract drafting. Okay. The whole misunderstanding is contract drafting means taking a template and then customizing it. Contract drafting doesn't work that way. Every single contract is a new contract which you will draft from the scratch. You can use other drafts for references. Using something for reference is a different thing, and understanding and creating your own content is a different aspect. Okay, so when I am sitting to draft a contract, there are a few questions that I need to ask my clients. Because if I don't ask my client, more than your senior lawyers, you need to check with your clients what do they need, because they are the ones who are going to sign this agreement. They are the ones who are going to, embed in this agreement. Okay, so that is their inputs which matter the most. When you are talking about protecting the business interest, understand what is the most vulnerable thing that they want to protect. Most of the times people enter into a loan agreement and they don't even understand that this is technically a loan agreement. For example, it will say that you don't pay repay the amount of XYZ. The agreement may be called just an MOU, but the content will be entirely different. For example, one simple thing I'll tell you now, in businesses also it happens. I know it happens in personal, also in businesses also it happens. uh, I'm sure you know that certain lands cannot be purchased, right? For example, properties which are owned by trust, properties which are owned by indigenous people or your tribal people, you cannot purchase their property. If you want to purchase property, there is a long run procedure for the same. That is, you have to go to the charity commissioner, get an order, etc. Now, you as an individual know this thing. But in reality, what happens, even I'll tell you something as close as that happens to home. In the suburbs, okay, in the suburbs of Mumbai, we have a couple of small places which are hamlets which are owned by indigenous people. They are not much educated, but they are rich. That is the whole problem. What they do, they enter into a power of attorney. So a lot of transfers happen with just a power of attorney, which is again, registered by some monkey lawyer or a monkey notary. Because until a few years ago, it was not even important to register a power of attorney. Uh, so they would just notarize it and get it done. Now, it also involves multiple stake owners. Now, let's talk about businesses. So, a lot of times, businesses, they also purchase such illegal properties. When you are purchasing a property, check what are the details. The checklist has to be formed by you. So, if you are you're doing a transaction for protecting the interest of your client, understand the requirement of a client, understand whether what he needs is legal or illegal, and then go ahead. If you were to purchase a trust property, you have to go file a petition before the charity commissioner. He will hear the case, both the parties, say why do you want to sell the property XYZ. Now, trust property cannot be sold at the normal property rate. So you will figure out the cost is much less, and then that order has to be passed by the charity commissioner. But what lawyers will do, sale agreement bana do. You don't mention it as a trust agreement. So one of the major reasons why we've had so many amendments recently in the ownership of property is because a lot of funny things like this keep on happening. Okay. So as a businessman, whether you're a businessman in a town, whether you're a businessman in tier 3 city, it is your duty, a lawyer. As a lawyer, it is your duty to understand all these details. Okay. Now, moving further, what is the other legal purpose? That is to avoid disputes. I'm entering into a contract so that today I will put everything clearly on the paper, and therefore tomorrow there will be no disputes, because all the terms, everything is put clear, black and white today itself. That was the whole idea behind having a what do you say? Having a legal agreement. Now, if I'm trying to avoid disputes, I need to address the issues which cause the dispute. What are the issues which are going to cause disputes? One is, of course, the compensation part or the consideration part. Okay, what is the consideration? How much are you going to pay? How are you going to pay? Payment nahi aaya to kya karna hai? All these are the things that you are going to check. If these terms are not clear, that is, if you're not paying on 10th, then I will give you 15 days grace period. Not after 15 days, then I will give you this grace period, that grace period. And ultimately, if you don't file on so and so day, then we are going to the court. Okay. Understand your problem, have the legal issue, have the documentation registered. Then comes your compliance with laws and regulations. When you talk about your contracts, okay, every contract is, as I said, it's something that is enforceable by law. So you have to ensure that all the laws are enforced. As I said, for trust deed, sale of documents, I cannot have a power of attorney. Similarly, in Bombay, you have an option of these MADA flats, or these are the government flats. Now, you are not allowed to sell them for the first 10 or 15 years. But sometimes people get their houses in MADA lottery, they are not able to maintain them, or for whatever reason, they try to sell them. What they do, 10 years you can't sell, again, power of attorney is waived. Now, these all are monkey transactions or illegal transactions. Try and stay away from them, or at least read the basic law and understand whether this is allowed in law or not. The purpose of a legal agreement is to understand the nature of the transaction. Okay. Now, your legal agreements, they will describe the vendor and supplier agreements. Who's the vendor, who's the supplier. You have your client contracts. You have your non-disclosure agreements. Okay. All these details, you will mention it. So these are different types of contracts. You need to have more clarity. You need to have a clause which will ensure there is no financial loss. Then comes my most favorite part, and what I do is intellectual property protection. Two people are entering into a business. I'm sure they are going to share some confidential information. Protection of this confidential information is your duty as a lawyer. Whatever is disclosed, whatever technology, knowledge is disclosed during this particular transaction that you have has to be protected. Now, most of the times people ignore it, thinking that it's just a random clause, it's only applicable to big people. No, it is applicable to everyone. You have to, in case of business contracts, you need to earn the trust of your investors, and you need to protect the same. So you need to have a clear relationship. You need to uh, have a clear cut agreement which is going to protect you as well as the other side. Any agreement which is one sided is a bad agreement. You may feel that you made your client happy, but in technical terms, we call it very, very bad drafting. A good agreement is a 50-50 agreement, which is very rare. And even if you want to draft an agreement fully in your client's favor, ensure it is done in a very smart mode. Now, if you see that a lot of your builders agreements, your insurance agreements, they are all prime examples of bad agreements because they are always one sided. They never help anyone. Moving further to your next concept, that is better negotiation power. Once you have somebody sign everything on a dotted line, you have better negotiating power. That is, he's taking it seriously and you are not there just for the sake of it. Okay, you are there to negotiate business. You are there because you want to grow together. You are there because you have some intentions in your mind. Moving further, so these are the basic principles on which your client is, drafting an agreement. Once your thought process, once why you are entering into an agreement is clear, then you will be able to start with your drafting. I'm not saying learn drafting, you will be able to start with your drafting. So when we used to do legal drafting, in the initial years, it was a big challenge for us also. One thing my senior told me to do is write down why are you, drafting this agreement. What exactly is the purpose? What does your client want? Does he want a relief? Is he drafting it because of ABC insecurities? Is he drafting because of so and so purpose? Whatever is your purpose with respect to the agreement, write it down. Okay, before you even start drafting legally, we used to have our notes which we used to carry during meetings. Why is the, and there were a few questions that we used to ask the client. Why are they entering into an agreement? One. Second, what does party A want? Party A, the history of party A is so and so. He's a company, she's a company. Okay, it's a company. How are they representing? And who is representing party A? So party A is represented by its director or its shareholder or whoever it is. And these are the documents which are supporting. So it will be most probably a board resolution. Board resolution is there. When was the board meeting passed? So when you are a lawyer, as I said, it is important that you also check into such small nuances. You cannot just mention a random board resolution and say that there was so and so board resolution in which person, according to which so and so person was appointed. Understand, pay attention to details and check which board resolution. Now you cannot appoint, you don't need to have a special board meeting or a special board resolution to appoint an individual. You can even do it in your monthly meetings. Okay, so when you are drafting, because board resolutions are not, honestly, no company maintains. 99% of the times we backdate them and put it because proof to lagta hai at the end of the day. So this is what happens, a little bit of jugaad here and there, but then that's fine. It as long as things are not harming someone, it's perfectly all right. Okay, so we put in the date that on so and so date there was a board meeting and then this was the resolution and so and so person was allowed to be appointed. Who are you going to appoint to represent? Okay, right now it may seem a very irrelevant point, but certainly when you practically apply, it turns out to be a very important and relevant point. So what had happened is a company, they had appointed one of their employees, and negotiating a contract, drafting a contract takes a long duration. Okay, especially whenever it is a high value duration. Midway, the employee quit. The company did not bother to inform us that, so and so Mr. in whose name we have, and we were very close to uh, closing the agreement and registering, because we never saw that person. Soon he turned out to be an ex-employee, and they wanted us to have that person as a signatory. It took, to say it's just a small line which we changed. We had to just redo the whole board resolution again, redo again the minutes of the meetings, keep the documentation. It was a tedious process, but as lawyers, it is your duty to ensure that only a person who is presently an employee or holds a board position, only in their name you can have a what do you say? You can have a document. You can have a board resolution authorizing them. The first thing, as I said, you have to know who are the parties to an agreement. So that used to be our first homework. Who are the parties? As I said, company represented by so and so. If the company has documentation, okay. Otherwise, create documentation. Sometimes while drafting, we also ended up creating a lot of paper trail. Now, second is the definition clause. Now, this definition clause is not very important, but most of the times when we draft large agreements like shareholders agreement and all, we use definition clause. What is the importance of definition clause? Because when it's a long agreement, we may just refer to certain terms. For example, in service agreement, I'm going to mention client may be someone who is an individual or entity who is at the receiving series of this particular agreement. Then comes your parties clause. Your parties clause I just mentioned. Please check the gender of the person. Okay, don't assume with a certain name that so and so person is a male or a female. Small things matter a lot in contract. Okay, it is details to paying attention to details which makes your contract more appealing. The way you format your documents, the way you present your clauses. So all contracts have to be printed on an A4 size paper, and their what do you say, font size is always 12. Anything more than that is a stress for the eye. Anything less than that is stress for the eye. Anything more than that is also a stress for the eye. Your documentation, the line spacing has to be 1.5. It cannot be more, because if you have it more, then somebody can write in between the lines. If it is 1, then sometimes it gets very cluttered. So try to keep it 1.5, select all, do 1.5, and you will get your solution. Moving further, the scope of work clause. Now, your scope of work clause may be divided into a lot of other sub clauses. Why? Because this is the most important clause. This is the clause which will define on what exactly is the role of the parties. Your scope of work clause has to be one of the most explicit clause, or it is one of the most detailed clause of your agreement. Okay, so you will mention all the details and then say that this are the deliverables of this party, this is the deliverable of Y party, and this is how we are going ahead with the agreement. Then comes your consideration clause. Now, when I talk about consideration clause, it is not a one-line clause. Just for the sake of your explanation, it may be shown as a one-line clause, but technically it is not a one-line clause. It is one of the most detailed clauses. So why are you entering into a what do you say? Why are you entering into this agreement? What is the payment that you are going to give? When are you going to give the payment? How are you going to give the payment? For example, in media industry, most of the times you make the payment within 90 days of broadcasting, like your television shows. So the artist is paid in lakhs, that is correct. They are paid per day, is correct, but they are paid after 90 days of the telecast of the show. So understand how the industry works, and then file the contract, then draft the consideration clause. Again, your payment terms clause. If there are any specific payments, there are any schedules, there are any methods that you would like to use it. You also have your late payment penalties. That is, how are you going to pay? What are you going to do in case of late payment? Like your builder's agreement will say that if you don't pay in 1 month, the next month we are going to add, you know, interest of 21%. So all these details you will add in the agreement. Then comes your confidentiality clause. What exactly is confidentiality? How do you have it? What is a non-disclosure agreement? Sometimes we have a separate non-disclosure agreement. So it is something that prevents unauthorized disclosure of sensitive business information. Implication, that is breach of an NDA, will cause legal action. One more thing, as future lawyers or in-house legal counsel, you need to understand is your role, especially when you are starting out, is also to explain the purpose of these agreements or these clauses to your employees. Now an employee is just going to sign the document superficially. He doesn't understand what is a confidentiality clause. He doesn't understand what is an IPR clause. He doesn't understand what is an indemnity clause. So at one point of time, there was a trend when the software industry had come in India. A lot of employees were taking their work home. Even I've had a lot of friends, when they started working out in ad agencies, they would just take their presentations home saying that I created it, and so it is my work. But technically, it is not. Why did that happen? Because nobody told them that, this is not your work, you cannot take it home. It's something that you have done during your employment. Most of the times people just get a ready-made employment contract, sign it, ho gaya, khatam. It doesn't work like that. Even boilerplate clauses like confidentiality clause, indemnity clause, your force majeure have to be explained to the client. Okay, one of the reasons why a client will return to you is not because of your actions. Your client will return to you only because if you have good relations, if you have open and clear communications with them. If you're not going to explain the purpose of why your client is signing on a certain dotted line and just ignore him saying that, it's none of your business, I will check into it, then it doesn't work. Then you're losing a client forever. If you want to grow in this profession, ensure that you also invest that much of time and money in the relationship. Okay. Now you have to explain them. For that, you have to understand what is the importance. Do I really need to add a certain clause? Now, sometimes we get agreements wherein irrelevant clauses are added. That is, they just randomly copy paste the clause from the internet and just add them. That is not done. That's a very bad drafting to begin with. Check whether your client requires this clause. clauses that we use in a shareholders agreement, and clauses that we will use for share purchasing agreement, clauses that we will use in share swap agreement are entirely different. The purpose of all three is different. The nature of business of all three is different. So how do you have clauses that are same? We may have the same boilerplate clauses, but those are also modified or customized sometimes. As a lawyer, don't blindly draft the contracts, understand them, and most importantly, explain them to your student. Okay, explain them to your clients. Okay, not students, your clients. Indemnity, again, section 124 of the Contract Act helps you with indemnity. It basically protects one financial a party from a financial loss due to other parties' actions. The indemnifier, they must compensate for any loss arising from the contract. That is, if party B, they delay in giving me the raw materials, because they delayed in giving me the raw materials, my production has delayed, and therefore because of that I am suffering a huge loss. My market is not my product is not going out in the market. In that case, party A has to compensate me. What is this compensation? How much is this compensation? All these details are mentioned in the indemnity clause. Draft your indemnity clause wisely. Okay, don't randomly pick up an agreement. 99% of the contracts that I've seen till now have ridiculous indemnity clauses because people don't check when they are, drafting an agreement. They just copy paste the same clause everywhere. As I said, not everywhere you need an indemnity clause. It is an option, not a rule. And even if you are adding, ensure to customize the same. Okay. Then comes your termination clause. What exactly is a termination clause? Some things go sour. Maybe I stopped manufacturing the product using raw material from party A. So my agreement has to be terminated. How am I going to terminate? Okay. So there are specific conditions under which the contract can be ended by either of the party. One is when it is no longer you can perform the party. All your details are given. Second, it will tell you what is the notice period, what are the refund policies, what are the exit procedures. Okay. For example, a consulting contract, it will say that either party will terminate this contract by giving 30 days written notice. You have a case law only for your reference. Okay. Moving further, when you talk about your notice periods, keep a standard notice period. Don't file something very ridiculous saying you need a 6 months notice period. For example, one thing that is going on in the market, the 90-day notice period. Is it a rule? No. Employee termination case, there is no law which says that you need to give 90-day notice period. So why is it a 90-day notice period? Because our lawyers were least bothered to rephrase it. 90-day notice period is nothing but a harassment. It also causes loss to the company because sometimes when it's a genuine urgency case, they have to they have to purchase the notice period of an individual. Okay. So all these things you have to be very careful about and ensure that it protects the interest of your clients and it doesn't create a wrong, what do you say, a wrong notion. You have to talk about refund policies. You're in consumer business, talk about the refund policies. If you are into an investor agreement, talk about the exit procedure. Now I'll tell you this very interesting case. So I did an investor agreement for a film. Okay, there were already two co-producers and one more investor entered. He also got the title of a co-producer, not the producer. So in film line also you have different types of producers. Now his job was only to give money and to also help them out financially in different matters. So the condition was, now it was a tri-party agreement, and they said that if this investor exits, okay, there will be a 90-day duration. We gave a 60-day duration, not 90 days, sorry, 60-day duration, in which he has to, now because in film investment and all things are very tricky. You don't know when the results will come. You don't know when the uh, film is going to be completed. What is the reaction going to be when it is going to be released and all. So you ignore it. So you can't be. It's more like a contingent contract. So what we drafted in that is that if the investor wants to exit, one, he won't get back his entire money. But when the movie is released, whatever is the X percentage of profit that was agreed, it will be reduced on so and so percentage. And during that time, we will again sit and renegotiate depending on the amount of investment that was made. One watertight clause we put in there was, now because he's an investor, he was already used to, he already knew all the in and out of the movie. That is, he knew who are the actors, who are the script writers, etc. So if he walks out midway, the investor, that is, if he exits midway the making of the movie, then in that case you have to file for a, then he cannot, even if the movie is shelved, he cannot create a story of similar lines with anyone else. Whereas if the other two producers who would exit, they could, continue the movie by getting in a new co-producer. So this was one of the crucial exit procedures that we had. So we spoke to him, and this was something that happens in the industry. Even though he was the one who was investing maximum amount of money as an investor, but the rights given to him were very less, because the other two parties, they were proper filmmakers, and along with money they were putting in a huge amount of expertise. Okay, so the exit procedure in a same document was different for different individuals. So you can have exit procedures which are different for different individuals, if it's a tri-party agreement or even a two-party agreement, but ensure that you have to make it much in detail depending on the requirement of your client. Then comes your force majeure clause. What exactly is the purpose? Now it protects parties from liability if there are unforeseen circumstances. Your contracts are either suspended or renegotiated under such circumstances. Now, sometimes it happens like suddenly during Operation Sindoor, certain regions had to shut down their business, or they had to work on uh, minimal staff. Now, in that case, it is not possible to give your 100% deliverables. They are either suspended or they are renegotiated. Okay, so neither parties, they are liable. Nobody is held liable in case of force majeure. If something is an act of God, something, there is a war going on in a country, so you can't say that you give me X percentage of uh, you know X percentage of my raw material right now. There was a huge cement shortage a few years ago. There was a huge cement shortage, due to which a lot of building constructions were delayed. That is a type of force majeure. Because of the law, the cement, there was a huge scarcity of cement, and therefore the construction had to be delayed. Then comes your dispute resolution clause. What exactly is your dispute resolution? That is, it defines how legal disputes are going to be handled. Whether in case of disputes, are you going for litigation, are you going for arbitration, mediation, etc. Then comes your governing law and jurisdiction. Under which law? Now, this is very important when you are drafting a contract for a multinational company, or you are drafting a contract for one company which is Indian, one company which is foreign. Okay, most of the time in commercial contract, you have to mention which state laws apply. Now, when you are drafting a contract, like for a shipping company, we had done for a shipping company a contract. It was an insurance agreement that we had drafted. When you are in high seas, you are in international water. So, which law is going to apply over there when you're talking about maritime law? After a certain nautical mile, you are in international waters and you can't do anything. What are the laws that you are going to apply? Similarly, most of the maritime law or most of these cargo cases, therefore, they surrender to arbitration. So you have a specific arbitration panel which is appointed, and they invest that much of money in getting a membership probably at Singapore, getting a membership at England. So two major arbitration hubs for international cases are Singapore or your London. These are the two centers which are quite famous and quite preferred. So you will go for institutional arbitration when you're drafting a commercial contract, or when it's a multi-party agreement. So mostly even for aerial laws. So even if you have disputes with respect to airspace, sometimes it's very difficult to, when if a plane is flying over an ocean, which is an international water, how are you going to disclose the location? Which laws are going to apply? Generally, what it says is about whichever country, there are two options. One, the country wherein the plane is registered, okay, the airlines is registered, either those laws will apply, or second, wherever the plane was flying, in whichever jurisdiction it was, those laws are going to apply. So most of the times when you talk about maritime law, when you talk about airspace and all, we have an option for arbitration, which is already given. Then in case of your space research and space debris, you have your arbitration law. Then comes your waiver clause. Okay, so your waiver clause, it states that in case if there is a failure to enforce rights under the contract, it does not mean that you are waiving off permanently. Now, the purpose behind this clause is that it protects the parties from accidental loss of legal rights. For example, a party's failure to enforce a breach does not prevent them from enforcing future breach. Okay, so just because I have given up, I have excused you this time for your breach of contract, does not mean that in future also I will be doing the same. Then comes your assignment clause. That is, whether it is contractual rights, it specifies when the contractual rights, they can be transferred from one party to another. Now, if I am hiring a advertising agency, okay, to design pamphlets for me, let's say. Now, this ad agency is going to design some creatives for me. As a creator, the rights belong to them inherently because they have created it. But according to copyright law, I am the one who's paying it. So if I'm entering into a contract with the ad agency, it is very important that I mention this assignment clause. Assignment clause is very important, especially when you are dealing with some work which is creative. So in business contracts, when you do about your software agreements, your um, you know your ad agencies, your media industries, assignment clause becomes very important. So I'll just give you an idea of how a contract looks. Okay, we'll go more in detail in our next session. Now, a well-drafted contract, it is basically crucial for ensuring clarity, enforceability, and legal protection under the Indian Contract Act 1872. It typically consists of the three key sections. That is, it has a primary section which has your introduction, your basic details, that is, who is entering into a contract, why they are entering. It will have your recitals, it will not anything and anything. Okay, so your preliminary section is basically anything and everything before the uh, body of the contract. So you will have your recitals, you will have your details of the part. Then comes your operative section. That is where you are going to mention what exactly are the core obligations of the parties, what happens in case if these obligations are not followed. Then comes your general provisions. It covers all the legal formalities, your dispute resolution, how, as I said, your indemnity, your what is that thing? Yeah, your indemnity, governing law. You talk about your all the other clauses. Okay, your complete agreement, waiver, doctrine of severability. So we also have a severability clause which says that tomorrow if it becomes illegal, any certain clauses held to be illegal, all the pending clauses will still be applicable. Okay, your confidentiality clause, IPR, they are all boilerplate clauses.